Now back to Inside West Virginia Politics with Mark Curtis.
And welcome back to Inside West Virginia Politics. The legislative session may be over, but there's a big political issue here in West Virginia that remains unresolved. We're going to talk about the right to work law. Joining us right now is the president of the AFL-CIO of West Virginia, Josh Sword. Good to see you here,
Good
Josh.
to see you, Mark. Thank you for having me.
This is crazy that I've been here 4 years as a reporter in West Virginia. We're still dealing with this issue.
Yep.
It was the big hot potato when I first got to the Capitol 4 years ago. Right to work was passed, and it was recently overturned by the Circuit Court. Talk about that.
Yeah, the original right to work law was passed in 2016. We filed a lawsuit challenging the constitutionality of it shortly thereafter. And last week, I know it's been a long 3 years, but a number of things have happened that delayed the ruling. Regardless, we received a fantastic ruling from Judge Bailey last week that essentially said the right to work law is unconstitutional. And she spent a great deal of time and went into depth as to why it's unconstitutional. Her ruling is about 46 pages long, and it identifies, a bunch of previous decisions that validate why it's unconstitutional here in West Virginia.
Let's talk about why you folks and organized labor in general was so against this bill when it was introduced and passed a number of years ago.
Yeah, well, what it does, it sets up an environment in which you have individuals that are receiving a benefit for nothing. I mean, that's essentially what right to work is. And in her ruling, she spelled out 3 areas in which she thinks it violates the state's constitution: the right of association, the illegal taking part, and our liberties. And the liberty part is the thing that really grabbed our attention when the ruling came out, because the West Virginia Constitution makes it very clear that we all have liberties, whether as individuals or organizations, that we shouldn't, by law, have to be required to do something for nothing. And it's a solid ruling. We're very pleased.
I want to talk about this to the non-labor folks out there, people who aren't in unions, and give them an explanation. So what happens in a right to work state? Does a person not join a union, does not pay dues, but then the union still has to protect them? Is that
well, there's a lot of confusion, and the other side keeps saying that before the right to work law that people in West Virginia actually were forced in some cases to join a union. That's just absolutely not true. That's a decision the Supreme Court made years ago. No one ever, under any circumstance in this country, can be forced to join a union. Now, what you may be able or may be required to do, depending on where you live and what kind of contract you have, you may be required to pay a fee for the services you get of the collective bargaining agreement. And essentially what right to work does is say you don't have to pay a fee for anything, regardless of the circumstances. So all the people that benefit from the collective bargaining agreement and the representation they get for being in that collective bargaining unit, who pay nothing, essentially get that benefit for free. And that's why Judge Bailey articulately ruled that it is unconstitutional per our state's constitution.
All right, she's not going to have the last word on this. Everyone anticipates this going to the West Virginia Supreme Court of Appeals, which is more conservative than it was a number of years ago. What are your thoughts about your chances of having this upheld by the state Supreme Court?
Yeah, it's a good point. We fully expect this to be appealed to the state Supreme Court. And if you look at the makeup of the court right now, it's a challenge for us, but I have to tell you, there's at least one, maybe more than one conflict of interest for individuals serving on the court. For example, Tim Armstead, who is a state Supreme Court justice now, was Speaker of the House in 2016 when the bill passed.
I mean, he favored it. Yeah.
He helped shepherd that bill through, so he clearly does not have an unbiased opinion, so he'll have to step down.
Yeah, I was going to say, do you want him to recuse himself?
Oh, and maybe more. I mean, there's another former lawmaker, both at the state and federal level, that serves on the court. There are likely instances in which he has made statements related to this particular issue, and if that's the case, there's no way the jury or the judges in this case can have an unbiased opinion on where we stand.
And we should name names. It's former Congressman Evan Jenkins, who served in the legislature here for a number of years. So when do you expect to see an appeal filed?
Well, included in her ruling was a 30-day stay, which essentially means that right to work will be the law of the land for at least the next 30 days. We fully expect the Attorney General to appeal, try to extend the stay, and then we work through the appeal process through the state Supreme Court.
How many states have right to work, and do you think that'll sway the decision?
Well, I've heard that a bunch, and about half the states have right to work, but what's different here is our Constitution is different from every other state. So you can say that, we have this law in all these other states, but it doesn't matter. We filed a lawsuit based on our Constitution, and Judge Bailey agreed that it's unconstitutional per the state's Constitution.
All right. Well, we'll wait and see what the appeal process
Thank
does.
you for the
Josh
time,
Sword,
Mark.
president of AFL-CIO of West Virginia. Thanks for being here.
Appreciate it. Thank you for having me.
We will have more of Inside West Virginia Politics after this break.